The term data or privacy can be referenced in a number of different documents, so we figured it would be nice to break it down into those which are company docs, which are traditionally non-negotiable, and those that are contracts. So I'm just going to touch briefly on what they are because we're going to get further into the substance in later slides. But with regards to company docs, as Val mentioned, a privacy policy, some may reference it as a privacy disclosure or a privacy statement. It's a document that explains how your website or business collects, uses, and stores or shares personal information. If any of us have been to a website, usually you can scroll down, click on a privacy policy. So this should be something that all of us are pretty familiar with. Next, we have our sub-processors and affiliates disclosure, which is where a company will provide information about the sub-processors that they use to process a data subject's personal information and potential affiliates if that's applicable as well. Val also mentioned the TOMS, or the Technical and Organizational Measures, which is a document that sets out an organization's privacy, security, governance, and compliance commitments, including the administrative, physical, and technical safeguards that are designed to protect data from loss, misuse, unauthorized access, disclosure, alteration, and destruction. So this is a chance where your security team can work in conjunction with you to set out a document that clearly lays out what you're doing internally to protect data. And lastly, with the company docs or cookie policy, if your company is dropping cookies, this is where you have a chance to highlight your company's stance with regards to them. But the meat and substance, I would argue, for this webinar in particular is contracts. So we have 4 listed here, which are the terms of service, the data processing agreement, your security addendum, and your BAA. The terms of service, or EULA, if in the case of a reseller arrangement, is where you're going to lay out not just your commercial terms, but there may be certain aspects that touch on privacy. I know that personally, I like to include maybe your caps for limitation of liability or indemnity within your terms of service or your MSA, which we'll get into that a little bit later. But it works in conjunction with your DPA if one is necessary. But the DPA, I'd argue, is where a lot of what we're going to be discussing today is, like, where that information can be found. So it's a legal contract between a data controller and a data processor in which you determine the rights and obligations of the parties involved in the data processing. So like I said, we'll get into each of the clauses a little bit later on, but this is just kind of like a where is it to be found in a high level.
So sub-processors are typically your, if you're a software company, for example, or in a number of other spaces, there would be your downstream vendors that you might be using to process data, for example. So in a sub-processing situation, if you're a SaaS company, for example, and you're using Amazon Web Services for hosting, they would be a downstream sub-processor. And so in contracting, you might not have your customer might not have privity with Amazon, but you do. And so you would typically have some kind of mechanism to disclose who you're using downstream.
Thanks, Val. So your security addendum, this may or may not be included in every contract negotiation, but as I mentioned the TOMS earlier, that's where your organization has a chance to lay out what they do internally to protect data. But some customers might want extra commitments with regards to your security posture, or have, a chance to kind of include some of what they might want to see that's not included in your TOMS. I have seen other entities try to force TOMS on people, but I typically like to argue for using ours, because it's where we showcase what we do, but then use the security addendum as a means to negotiate maybe some nuances that weren't included or that they'd like to see. And then lastly, your business associate addendum. This is not applicable in every instance. This is specifically, if under HIPAA, if you're a covered entity is having you, a business associate, take on a certain of their obligations, then a BAA might be necessary.